So as I said in the previous video, now we'll do the last fundamental right, which is article number 32, which reads as right to constitutional remedies. Now you'll see कि थोड़ा सा different सा नाम है, they are telling you कि constitution आपको कुछ remedy provide कर रहा है with the help of this right. So what is this whole idea of providing remedy with the help of another right itself? Because it is also a right only, and that too fundamental right. So what is this whole idea? Before understanding the details of this right, I mean you would say, let's say the interpretation of this right, firstly we'll see the contents of these right, because until and unless you understand what this right is giving you, what is the point of going ahead and seeing that why did we need this right? So let's first see that what this right give you. Firstly, it is telling you that we are providing certain remedies for the enforcement of the rights conferred by this part. This part means part 3, which is dealing with fundamental rights. So they are telling you that in this part 3 of the Constitution, fundamental rights, whatever rights we have conferred, we are giving you the remedies for the enforcement. Because this might happen that these rights are not practically enforced even if it is mentioned in the Constitution. So you need a mechanism to enforce it also, right? You need certain remedy for the enforcement. Otherwise, mere existence of these rights or declaration of these rights in the Constitution just as a text, will it make any sense? Will it be useless? Will it be of any use? No, it will be useless, because there has to be certain means to make it effective, and therefore this is that means. Okay, now the first clause of Article 32 says the right to move the Supreme Court. So firstly, in the remedy, how you are getting the remedy to enforce or to get the right enforced, that you can directly go to the Supreme. Move means going to the Supreme Court. Okay, so you are getting the right to move the Supreme Court by appropriate proceedings. Definitely it's not that you will someday just randomly go to the court. It means that appropriate proceeding, but directly Supreme Court के पास आप जा सकते हो for the enforcement of the rights conferred by this part. And this is a guarantee. Understand this. This itself gives you the idea that Supreme Court को guarantor of fundamental rights बताया जा रहा है by the Constitution itself. And this question had been asked in the prelims also. So I hope you're getting this idea clear, that with the help of appropriate proceeding, you can directly go to the Supreme Court if any of your fundamental rights are not given to you or they are not enforced, and that is a guaranteed right to you, because this guarantee is also given by another fundamental right only under Article 32 under this Constitution. Okay, what does clause 2 say? Supreme Court. Now if you go to Supreme Court to say that okay, my right is not given to me, or it is infringed, the court will have certain rights to go ahead, proceed. So the Supreme Court shall have the power to issue directions or orders or writs. Now writs are also kind of orders only. For the time being, just understand this only, because in the next video we'll have a separate discussion on writs. So just understand, certain directions, orders or writs can be given by the Supreme Court. And this power is also given by the Constitution only. Now, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now, these are the 5 writs, important ones that you have to remember, and definitely, as I said, we'll do in the next video. But understand that the names of these writs, or let's say the nature of these writs, are already clarified in the Constitution itself. Okay? Acha, whichever may be appropriate. So based on, because all of these are depending on certain situations. These are the kind of writs which the courts can order, and it will depend on different situations. So in different situations, they will order in different mechanisms. Therefore, whichever may be appropriate, the court can do that for the enforcement of any of the rights conferred by this part. This part means part 3. Then another clause says, without prejudice to the powers conferred on the Supreme Court by clause 1 and 2. Clause 1 and 2 means these two. that you are directly going to the Supreme Court to ask for the enforcement of your right, and the Supreme Court has the power to issue these directions orders and these specific writs also, without prejudice to these powers. Without prejudice means that not curtailing the power of the Supreme Court. जो है वो रहेगा उनके पास, वहाँ पे there will be no prejudice. But the Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. Now understand this. What was given in clause 2? That what are the powers of the Supreme Court? What are the powers? Direction issue करना, order issue करना और writs issue करना, and they can include these writs. ठीक है? So Parliament, without curtailing anything given to the Supreme Court under this, can make a law, and by that law the Parliament can empower any other court. Now here any other court will mean any other kind of subordinate court. Understand this. When we were doing the basics of judiciary that I had done earlier with you already, I hope you should have got that clarity. So we have seen how we have an integrated judiciary, Supreme Court, then High Courts, and then the subordinate courts has altogether a different layer. Understand, Supreme Court को ये orders वगैरह issue करने का right कहाँ से मिल रहा है? Article 32 से. For the fundamental rights infringement I'm talking about, not anything in general, only for the infringement of the fundamental rights. The Supreme Court is getting the right to issue these orders under Article 32. Now there is another Article 226 through which High Court also gets the same right of issuing order. But apart from these two courts, no other court has got the right. In the case of fundamental right I'm talking. Okay. But if Parliament want, by law, they can empower any other court also with the similar rights. It's just that the jurisdiction area will be limited, definitely local limitation hoga, but still they can give these rights, although it has not been done yet, but this is a right available to them. Okay, and understand here any other court will not imply High Court. Why? Because High Court is already giving this right through our constitution. It is just about the subordinate courts. Okay. And the fourth clause says the right guaranteed by this article shall not be suspended except as otherwise provided for by this constitution. So this particular right you cannot suspend. Article 32, which is the right to constitutional remedies, you cannot suspend except the conditions which are given in the constitution itself, which you will see when we do the topic of emergency. तो उस पर हम बाद में बात करेंगे, बट अभी के लिए जस्ट रिमेंबर दीज इम्पॉर्टेंट पॉइंटर्स. नाउ वी विल ट्राई टू अंडरस्टैंड अबाउट सर्टेन explanations. These are the same things which are given, that these are the four rights you have got from the constitution. Certain additional thing, the first thing that we'll try to answer is that why did we need this right. And as I've said you also, that mere existence of this right as a text in the constitution will not make any sense. It will just be useless until and unless we have a mechanism, we have a method, or we have a means to enforce them or make them effective. And therefore we have to bring the courts in between. Also, it is the courts, that the court has the power of acting impartially and independence hai judiciary ka. But at the same time, the court also has the power to declare any law which is not in consonance with the constitution as void, and also check arbitrary actions of the executive. ये हमने पढ़ा हुआ है. So judiciary's power are very broad, very wide, right? Therefore we need mechanisms to enforce these rights. And therefore, considering the significance of this, Dr. Ambedkar had said that this right is the heart and soul of the constitution. He said that if you ask me that which is the most important right amongst all the fundamental rights, I will name this Article 32 to be the most important right. Why? Because every other right will be having certain meaning only if this right exists. नहीं तो merely existence on paper will not make sense, and if you cannot have a mechanism to go to the court and ask that my right is not being given to me. What is the point of having it? Therefore, this is this right, Article 32, which ensures that all other rights are also taken care of. Therefore, according to Dr. Ambedkar, this right is the heart and soul of the Constitution. And considering its significance, Supreme Court also declared this right to be a basic feature of the Constitution. Okay. Then we have also seen about that how Supreme Court is the guarantor of the fundamental rights, also defender. So the Supreme Court gets original and wide powers in this context. Why original? Because you can directly go to the Supreme Court. Why wide? Because they can issue writs of all the kinds. We have seen that. Also, very important thing to remember that only the fundamental rights are guaranteed by the Constitution and they can be enforced under Article 32. So whatever guarantee you are talking about, and under Article 32, if Supreme Court is involved, they will only deal with the matters wherein your fundamental rights are infringed. No other matter. Let's say legislature has made a law, executive implemented that law, and the people found that there are certain issues with the law also, let's say the provisions, and certain issues with the implementation also. Still you cannot directly go to the Supreme Court under Article 32 until and unless that law or that execution is directly infringing your fundamental right. This is what is written here, that Article 32 cannot be invoked simply to determine the constitutionality of an order or legislation. That a law is made or any executive order is made and we want to see कि ये constitutionally valid है या नहीं. That is the work of the judiciary, but they will do it under different powers, not under this Article 32. ठीक है? Unless it is directly infringing any of the fundamental rights. You also have to remember that despite it being original and wide power with the Supreme Court, it is not an exclusive jurisdiction of Supreme Court. Why? Because High Court also gets the same power of issuing orders and writs under Article 226 for the infringement of fundamental rights, which I have discussed with you. When I was discussing this is what I discussed with you. So it is not exclusive. Exclusive क्या होता है? Which is only given to that particular entity. So here it is not only given to Supreme Court, it is given to High Court also. ठीक है? So it is not exclusive, but it is original. Why original? Because you can directly go to the Supreme Court. You do not need any mediations in between. ठीक है? However, considering so much of cases, pendency of cases, and even people might go to smaller court for the smaller matters, despite the idea that the Supreme Court cannot reject your plea if you are going there with a claim that your fundamental rights are infringed and there is truth in this legally and constitutionally, the Supreme Court cannot say and reject that I will not exercise my power, because under Article 32 Supreme Court is bound to do that because it is a fundamental right. But still, considering the easiness, how the judiciary can manage, because there are so many cases pending and many of the people might not understand about the severity of the issue, so the Supreme Court has recommended to the people that if relief through High Court is available, if alternative is available, and if you can get the relief through High Court also under Article 226, please aggrieved party should go first to the High Court, so that Supreme Court deals with the more important matters. But still, if you go to the Supreme Court directly, they cannot reject it. But they have just recommended it that please move first to the High Court if you can get the relief under Article 226 via High Court. Okay. Now, in the next video, we'll discuss about the different kinds of writs, etc. Here, I end our discussion on right to constitutional remedies, which is article number 32. Thank you so much, guys. Take care till then. Bye-bye.